I'd like to start by telling you about the Cicero system of circumstances. Cicero came out with what came to be known as the Cicero system of circumstances, which is the 5 W's and the H, which is whenever you're talking about any subject, whenever you're making any police report or any other report, inquire about the 5 W's and the H, which is why, when, where, which, what, and how. And when one looks at that and the topic at hand, the questions that were posed to us in that little introductory note was, why litigation? Why would one resort to litigation? And I'd like to look at that just a little. And that's an interesting question, because if you read about Mother Teresa, at the time when somebody copied Mother Teresa's name and image on a t-shirt with hamburgers. So if you're talking about a giant like India's largest jeweler, they got a notice from Cartier because they were coming up with watches under the Cartier brand, gold watches, which had about 80,000 rupees of gold in them, but were selling for about 1,25,000 because of the Cartier name. They were caught red-handed, and once they were caught, and that settled in 24 hours, because they were really keen to have their names not appear on the front pages of newspapers. Or I remember when SAP started their campaign for the first time, they took actions against a large number of educational institutes, each of which had a huge reputation to protect. So all those cases got settled in 24 hours, 48 hours, less than 1 week. Why? Because none of them, one of the first conditions was, don't go to the press. We have a good name, we don't want that name sullied. Or when NASSCOM did a case against India's largest HR agency at that time, it was a case of phishing, the tort on the internet, PHISHING. That settled within 20 days with a proper damages award of 16 lakhs of rupees. So these are kind of cases where companies would, in response to a cease and desist letter, they might give up. Or it may well be that you're business partners and you want to preserve your relationship and continue to remain partners, when a cease and desist letter may get from one chairperson to another chairperson, might get the parties talking, you'll settle, have an amicable discussion, they'll deeply appreciate that you didn't go to court, and the matter might settle. There may be other cases where parties have a huge conscience. There are certain business groups which are very particular that they do not wish to violate other people's intellectual property. They've made statements to that effect on their websites, and if they receive a cease and desist letter, the chairperson will take it as an attack on his ethical values and might want to give up. Beyond the cease and desist letter, there can be a lot of variations. One variation which is very interesting is called a CPU, a counterfeit purchase and undertaking vehicle. Now what's a CPU? The way it works is, rather than just giving a cease and desist letter and then waiting for a response and then sending another letter and then having a battle of documents through correspondence over a period of 6 months and 1 year, nothing's happened. The counterfeit purchase and undertaking route means 2 lawyers will go armed with documents, armed with previous orders, make a purchase, maybe 1 lawyer and an investigator, make a purchase, and the moment they find a counterfeit, they confront the owner or the proprietor or whoever else may be involved in the shop at that time. They confront them and say, if you sign this undertaking now, then we can give up our case, otherwise we have these papers ready to go to court. And that works beautifully well. There are a lot of companies who, instead of resorting to cease and desist letters or resorting to litigation, would adopt a low-cost, quick remedy like this, so it immediately clears the market, and particularly in markets where the goods are completely flooded, that's one way to sweep the market clean.